Hi folks, you're with Tacitus today at your Pushback channel, and thank you for joining this radio live stream. There's a couple of things I'd like to talk about regarding the changing nature of jurisprudence, the practice of law in the West. Now, certainly in, say, Britain, America, and Australia, Canada, that sort of thing, there's been I believe, seismic changes in the way the law is practiced, the court cases, how cases are prepared, the sort of evidence that's considered, the due legal process afforded to each of the litigants, and so on. So we're seeing, I think, a change that urgently needs to be reversed. But let me talk a little bit about it. And I say 20 years ago, 15 years ago, that sort of thing, if you went and looked at a court list, it was if the state was bringing the case, like the Department of Prosecutions, Justice Department was bringing the case, it would be, murder, attempted murder, drug dealing, fairly major things. Not that there weren't, smaller level stuff. There were, but it was all a deliberate, or what was alleged a deliberate transgression against a clearly codified law. There was no ambiguity there. You were exceeding the speed limit by X, and here's the report. Here's the readout from the speed meter to prove it. So it was fairly straightforward. Now there were petty sessions cases where citizens could bring a case against somebody, and there was no government involvement. So you would see things like two senior citizens, retired neighbours, where one would accuse the other of cutting down the roses or something like that. So you got those as well, or petty amounts where neighbours may dispute for the cost of, say two neighbours agreed to pay half each for a fence or something like that, and one later refused to pay, and these sorts of things. So. Now, but it's different today. Take a look at the court lists today, and even in the fairly senior courts, where custodial prison sentences are given and that sort of stuff. You have a look at the court listings, and there's an amazing number of cases that things like rape cases. Or sexual assault, or those sort of feminist type ideological crimes against feminism, rather than actual crimes. And in the employment courts, then the allegations of racism are just, I don't think there's almost anything else there. Or misogyny. So through the employment courts, racism, misogyny are just shot through the place. Now, there's a couple of reasons for this. One is where somebody may say, well, the boss just didn't like me, or something like that, and then treated me unfairly as a consequence. Now they would say, that if it was a female employee, it'd say, well, it's misogyny. He tried to rape me or made sexual advances. Or if it was a black woman, he's a racist and he tried to rape me. So those are the sort of things that are around now, things that you didn't see before. And if you saw them, they were very rare. But it's ideological now. And if you look at the way that the courts, and I've sat in on a few cases just to watch, and the Department of Prosecutions, or the lawyers representing the black lesbian, they're deeply Marxist. That the amount of Marxist phrases they utter, and the very Marxist type structure of victimhood, and how they attempt to create the narrative, ideological narrative of their client is a victim of racism, of misogyny, of evil white males, of Nazis, of fascists, of Hitler, and that sort of thing. It's very much ideological now. Even and also, say in the case of rape, now there's the definition of what constitutes rape or sexual assault has been expanded some more, then expanded again, and then expanded a bit more on top of that for good measure. So now, for example, say a fully clad male, with all the the zipper done up and a fully clad female. If he grabs her and dances with her, what would be viewed suggestively, that's now considered a sexual assault, for example. So what might be sexual assault has been expanded, and there's verbal sexual assault. So there's one case where the guy commented on the girl was wearing like I don't know, fishnet stockings or something, and the fishnet stockings had a tear in them, and he commented on that, and that meant that he was sexually assaulting her with his eyes or something like that. So they expand the definition quite considerably, and in these ideological courts, not only are they applying ideology rather than facts, but everybody knows all straight white men are fucking fascist, Nazi, racist, oppressors. We know that. So these cases are almost starting from that position with a reversed burden of proof. So he has to prove that he didn't do it, even though the evidence in factual, physical terms doesn't exist. It's ideological. Everybody knows that you're a fucking fascist Nazi. So you can't prove that you're not a fascist Nazi because you are, and all fascist Nazis are rapists. So you have to prove you didn't do this. And they tend to go in that direction. Now, if a custodial sentence is involved, then there is a higher burden of proof, but not so much in the ideological sense. There was a recent court case where while the woman was being cross-examined, even though there was no physical evidence at all to suggest that the man was guilty of rape or anything resembling that, she was permitted by the judge, and the judge didn't, as I understand it, didn't stop her, where she just called out across the courtroom to her alleged, remember, nothing's been proven, she's allegedly a victim and he's allegedly a perpetrator. She called out to the alleged perpetrator right across the courtroom saying, "Oh, I know what you did to me. You did it to me. Yeah, you fascist." And that wasn't pulled up, and that wasn't the judge should have jumped all over that. I think should have issued some sort of a severe reprimand and instructed, indeed ordered the jury to ignore that. And if you make an utterance like that again, you will be held in contempt of court. Do you understand that sort of thing? But that wasn't done. So a lot of leeway is given to the ideological victim. So the structure of court cases has been there is an ideological victim and there's an ideological oppressor, and that there's more and more cases. In fact, I would argue that the court is clogged up with cases now where ideology is as in gender ideology, race ideology, Marxist ideology, and is shot through with that. Now, not only that is that most of the prosecutors, in fact, you'd be hard pushed to find a prosecutor that hadn't been brought up now in the era of ideological legal studies, that facts don't really matter. It's not that. She's a black lesbian. She is oppressed, and we know she's been oppressed. We don't have to, that doesn't have to be on trial. We know that he's straight and white. He's the oppressor. We don't have to have facts to support that. That is a given. We go into court in that position. Therefore, he should get a higher burden of proof. And if she commits perjury, then she should be allowed to do that because she's an oppressed victim. Whereas if he commits perjury or even isn't quite as exact with the truth that we need to get him on, then he should be held to the highest standards and of perjury and contempt and so on. So there's different levels of punishment, and you can see these in courts where if she the so-called alleged ideological victim alleges something, then the judge will very quickly take, well, that's fact. You've alleged it, even though there's no evidence, there's no witnesses, even on balance of probability, it looks rather weak. I'm going to accept it as fact. That is now fact. The court says so. And you Mr. Straight White Male, You have to prove now that you didn't do it, because as far as the court's concerned now is you did. You must prove you didn't do it. And I'm going to set the bar of evidence that you have to be very high. You have to prove that you weren't even in the universe at the time if I'm going to accept you didn't do it. You can't prove that. You're damn guilty, motherfucker. And so it's those sort of levels of ideological absurdity that are being applied. Now, again, if there's a custodial sentence, the burden of the bar of evidence is set a little bit higher, but not too much. So we're seeing courts are being clogged up with ideological cases, misgendering someone, these sorts of things. So clearly, now the courts have been given over, as indeed has the justice system, been given over to of being sort of de facto proxy representatives of the globalist project. They're there to clear the way for the globalist project by crushing white society and straight white males and so on. And part of this is allowing what would once have been considered as silly, irritating nuisance lawsuits. And there's just an avalanche of those. Again, the rape and the misogyny and misgendering, all these sorts of ideological crimes. They're not real crimes, for Christ's sakes. They're ideological crimes, but yet they're very effective, extremely effective at undermining Western society. And it means that the cases that should be getting to court are not getting to court. The departments of public prosecutions or justice departments are going chasing after petty, idiotic, he said, she said, rape cases without physical evidence, but they're still chasing after and going to court. But they're not going after the cases that, in my view, should be chased now. So they're prepared to cop low-level plea bargains on out and out murder cases. So well, look, even though you premeditated the thing and dismembered the body and this, and murdered 100 people, hey, who cares? Look, cop a plea bargain to involuntary manslaughter, do a few years in prison, we're done, thanks. And that's become the processing machine, the quick and dirty processing machine. Whereas on the other side now, they're wanting to get as much precedent and really go after these ideological crimes. So that now the other thing that's also being used now is bringing these ideological crimes into civil courts, and this means that there's a fine rather than, say, a prison term, for example, or it would get kicked up to the higher court in the event there was a custodial sentence as an issue. So what they're doing is they're dragging a lot of these ideological crimes into the civil courts, but they're using something that's been now more widely used. I think it's ever been used, and in my view, being abused in a wholesale fashion, is that the courts are placing orders upon the straight white male. They don't do it to the oppressed party. So it's typically the straight white male. So the courts are placing an order on the you will pay this, or you will do that, or you'll do so and so. And a lot of it's quite unreasonable. The person can't do it. They're going to have to quit their job to do it. And they don't want to quit their job, but then that puts them in conflict with the court over this court order. Now, the courts then use the power of, or the technicality of, contempt of court. The court order you do this or that. You didn't do it. You are therefore in contempt of court. Then the court has sweeping arbitrary powers to issue punishment, which can include a prison term. So even though the person's committed no crime, they've been accused of misgendering someone, they're told they have to do 500 hours community service, but only during weekdays when they're working. So the court deliberately, these ideological courts deliberately place the person in conflict with the court order, their natural run of, as in going to their work, place them in contradiction of the court order, but also give them a fine. So they have to work to pay the fine. So if they don't then do the community service during the week, then they're in contempt of court. So they'll be put in prison. Now, the court can then order that you still owe the money for the fine. And by the way, it's going to accrue interest and going to accrue other charges for late payment. So they can put you on that merry-go-round where you're constantly being fined or transgressing a court order of some sort, or in prison for contempt of court, even though you never committed a crime in the first place. And that little 5-card trick is one that's being increasingly played and used against white people. I would argue, in my view, against straight white people all across the West. And again, it's part of this wider thing of getting back at the oppressor, of fighting back against Hitler, and this sort of thing. And there's an entire, I believe, there's an entire legal establishment that's quite okay with this. We all know that those damn fucking white supremacist fucking fascist Nazi Hitlers, they've been oppressing the world for centuries, thousands of years. We're only giving them some of their own fucking medicine. They deserve it. We're only getting back at them and helping out those poor oppressed people and representing them and helping them in this wicked, evil, fascist, Nazi oppressor society that we're gonna change. So let's put this guy in prison so we can go to that climate change march. Yeah, hey, yeah, Shaniqua, yeah. So these are areas I think of deep concern, and one where we have to get back to a situation where the rule of law is applied equally, and when due legal process is applied equally. Now, if that were to happen, due legal process is a case in point. Nearly all of these cases would fall over because they're so ideologically based and rooted in such insane ideology that that's the only thing that allows them to either get to court and to be remarkably successful in the conviction rate, in my view. You've been Tacitus today, your Pushback channel. Thank you for listening.